Hello. Thank you very much to everyone who has been who queued up in advance to get into this. We're going to give about 30 seconds or so to allow people to continue to enter. We have a lot of interest in this webinar, as I'm sure you can imagine. So we want to make sure that we are respecting everyone's time, but being a little bit not being too Martinet-ish in when we start. Hello, good morning, everyone. Thank you so much for taking the time to join us today. My name is Dara Lind. I'm a senior fellow at the American Immigration Council. I'm here with my colleagues, uh, Adriela Rosco, a senior policy fellow or senior policy counsel here at the council, SEL and CIL respectively, if you're taking notes. Our policy director, Nana Gupta, our senior fellow, Erin Reitland-Melnick, and our legal director, Michelle Lapointe. The four of them are going to walk us through the most significant actions, both executive orders and other actions carried out by the executive branch in the first 10 or so days of the Trump administration, which amount to a fairly sweeping agenda to aggressively expand both the people in the US who can be deported and the infrastructure available to deport them. An effort to completely seal off asylum at the US-Mexico border and replace it with full militarization, and efforts to restrict and create obstacles and barriers for people who are trying to immigrate legally to the US in a way that is likely to create substantial burdens to the legal immigration system in the future. I'm going to turn it over quickly so that we have some time to get to both speakers and Q&A. If you have questions while the speakers are talking, there is a Q&A function on Zoom. You can type in your question. Some questions we may want to get to by just typing in answers for you, but some will want to get to the Q&A once the speakers are finished speaking. With that, I'm going to turn it over initially to Adriel to talk about the policy changes to legal immigration that we've seen in the first week and a half.
Great, thanks, Dara. Good morning, everyone. Thanks for joining us today. So President Trump's Day 1 executive orders impact some lawful immigration pathways to enter the United States. All are, or most of them are humanitarian-based programs, and many were expanded during the Biden administration. It's really important to emphasize that while the orders largely were instructions for future action by federal agencies, some of these pathways were immediately impacted. So I'm going to start off first with parole. So two of the executive orders gave instructions to the Department of Homeland Security to end what are referred to as categorical parole programs. These programs allow people to temporarily enter the United States for up to 2 years, or at least most of them. They included established guidelines for who could be eligible, but each application was reviewed individually. So parole programs were established and expanded under the Biden administration to provide people with an alternative way of seeking entry into the United States from particular countries with particular crises without having to present themselves at the US-Mexico border. This was extremely successful, and the numbers of folks from these countries who presented themselves at the border generally decreased. In the orders, President Trump continuously referenced people who had entered lawfully under these programs and whose presence is still authorized by immigration laws as quote unquote illegal, I'm sorry. So in a lot of ways, the executive orders included this language to delegitimize their presence in the United States. The EOs or the executive orders specifically referenced a particular program for nationals of Cuba, Haiti, Nicaragua, and Venezuela, more commonly known as a CH&B parole program in immigration spaces, which is a sponsorship initiative for folks to be able to come into the United States from those countries. Nearly 530,000 people benefited from this program. On the first day of President Trump's term, we actually started hearing reports and confirmed that the CH&V program was suspended starting on that first day on January 20th. It is important to highlight that people from these countries are still experiencing political and humanitarian crises despite the suspension of this program. At that time that we heard about the suspension of the CH&V program, it was unclear if and when other parole programs would be suspended as well. The executive orders were broadly worded. However, this past Wednesday, we did hear reports indicating that other parole programs had officially stopped accepting applicants. So this included people requesting parole into the United States from Ukraine, which is the Uniting for Ukraine program. Folks were being allowed to be paroled due to the humanitarian concerns there from the war with Russia. We also have seen that parole for Afghans who have been experiencing insecurity due to the Taliban's takeover of the Afghan government after the US withdrawal there that had taken place in August 2021, that was also suspended. There are other parole programs that were established or restarted during the Biden administration, but in the interest of time, I'll skip going through them. But if anybody has any questions about those programs or what those programs are, happy to answer them in the Q&A portion. The executive orders also called for a review of all designations made under the Temporary Protected Status statute or program. TPS was established in 1990, and it allows the federal government to provide authorization for people to temporarily stay in the United States if their countries have experienced some type of conflict, like armed conflict, political turmoil, or natural disasters, which makes it unsafe for those folks to be able to return back to their countries. As of September of last year, there are just over 1 million people with TPS in the United States. And there are 16 countries currently with TPS designations. 13 of those 16 have designations set to expire in 2025. Just before President Biden finished his term, on January 17th, his administration extended TPS for 4 countries in particular, which were El Salvador, Venezuela, Ukraine, and Sudan. El Salvador's TPS designation was set to expire in March, Venezuela, Ukraine, and Sudan in April. Nearly 1 million people were set to benefit from these designations. Yesterday, we found out that the Department of Homeland Security is actually vacating the extension for Venezuela. The new designation was set to expire in October of 2026, and the revocation or the vacating of the TPS designation argues that because DHS, as a federal agency, has the authority to review its prior decisions, and because Venezuela had 2 prior designations that were seemingly combined into one by the Biden administration, it was a novel approach which caused confusion, and therefore they were going to take a new look at that designation in particular. So, that's what we've seen so far with TPS and what's happened. The last part is around birthright citizenship. I know that Michelle is going to talk more about the legal cases around it, but the Trump administration tried to redefine U.S. citizenship in the country. If anybody has any questions about that, we can get into more details about it, but it's important just to know that that executive order is actually paused due to litigation and not in effect. So I'll go ahead and pass it over to our next speaker.
Thanks so much, Adriel. Hi, everyone. I'm Naina Gupta. I'm the policy director here at the council. The executive orders signed on the first day of Trump's second term radically expand enforcement in the interior of the United States in our communities. You all are undoubtedly seeing and hearing about this through propaganda, headlines, and on the ground through communities who are feeling both the threat and actual increases in arrests. I'm happy to highlight some specific changes that we've seen since last week, but I do want to mention up top a few trends. We've heard the Trump administration talk about targeting criminal immigrants, but this set of changes targets very many immigrants who have no criminal records at all, or for those who do, who pose absolutely no public safety threat. Based on recent data, we know that fewer than 1 in 10 undocumented immigrants has a criminal record. So to reach the number of arrests and deportations the Trump administration is marketing, they will necessarily have to target folks without criminal system contact. Second, these executive orders terminate the enforcement priorities that were set by the Biden administration that tell immigration officers who to prioritize and focus on for enforcement of immigration law. The Trump administration has not replaced those. When no one is a priority for enforcement, everyone becomes a priority. That means that people on the ground don't know if they're at risk when they leave their homes. This is what leads to a chilling effect where folks are less likely to come to work or to school. The third trend to highlight that the actions we see from Trump on the interior take explicit action to criminalize people who pose no threat to our safety, but yes, who are in violation of civil immigration law. They are proposing using a handful of existing criminal statutes against all undocumented people, and using prosecutorial discretion to that degree is unprecedented. In terms of specific changes to flag, the Trump administration has moved toward an expansion of expedited removal, which authorizes U.S. officials to arrest somebody accused of entering the country without inspection anywhere in the U.S. who's been here, who's been accused of being here for 2 years or less, and subject them to rapid deportation without a court hearing. A DHS memo last week signaled the use of expedited removal, including for people who were granted parole. So people who came here through a lawful program who would now be losing that. My colleague Michelle will speak to litigation that's been filed to challenge this expansion. We've also seen an expansion of collaboration seeing a move to expand collaboration between federal immigration authorities and local police officers. Over the past decade, about 75% of all ICE arrests in the interior have happened as handoffs from local police. That's always been the case. What Trump is proposing is expanding that collaboration by making more agreements that actually give local police themselves the authority to act as immigration officers, including local police putting people directly into removal proceedings. They'd be doing this through 2 programs, one under 287G of the Immigration Nationality Act that already exists, or through a new authority referred to as the mass influx provision under the law. We have 2 resources on that at the council that can answer more questions. These programs do have a history of resulting in racial profiling and leading to misidentification of citizens for removal proceedings. Finally, the orders we saw in the interior target undocumented people and their livelihoods. These propose enforcing with criminal penalties a provision that would require undocumented people to register with the federal government, propose taking away any benefits they may receive. And we are seeing in real time across the country at-large immigration arrests in communities, not targeted enforcement actions that could sweep in also U.S. citizens and others with lawful status. It's worth noting that some of these changes being proposed to the livelihoods of undocumented people are right now just threats and would require further regulations and actions that we'll be waiting to see. 13 million undocumented people in the United States are here today, and 80% of them have been here for more than 15 years. Many pay both federal and state and local taxes. They're essential to key sectors of the labor market, agriculture, healthcare, and construction. And this attack on their communities, again, is unprecedented. Finally, before I wrap up, I do want to mention one additional change that we saw last week. The Department of Justice instructed legal providers to stop work on a long-standing suite of legal access programs in immigration court that serve children, adults, and families at risk of deportation. Access to legal counsel is critical to a functioning justice system, and a lack of legal counsel in immigration proceedings can, of course, lead to devastating outcomes. Ending these programs does contravene instruction and intent from Congress. These are programs appropriated by Congress, and we expect legal challenges to the termination of these programs. So with that, I will hand it over to my colleague, Aaron, who will speak more about the changes we saw on the border.
Thank you, Nina. My name is Aaron Reichlin-Melnick. I am a senior fellow here at the American Immigration Council. I'm going to talk about the policy changes at the border and the expanded ways in which the Trump administration is using the U.S. military. So I'm going to start with the border. The biggest change that's happened so far is that the Trump administration, it's only been a couple of weeks, still have some old habits. The Trump administration has eliminated the use of the CBP-1 app process, by which some individuals were able to seek protection and start the asylum process by going to a port of entry with an appointment. The Trump administration has terminated this process, meaning that as of today, there are effectively no ways for migrants to seek asylum at ports of entry along the southern border. We continue to monitor the situation to see what happens with people who go up to a port of entry in person, but at this moment, we believe that asylum at the southern border is effectively impossible to access for migrants going through ports of entry. It is also effectively impossible to access for migrants going between ports of entry, as provided in U.S. law. That's because President Trump signed executive orders that instruct DHS to turn around any migrant crossing the border and to deny them any legal protections that are available in the Immigration and Nationality Act. President Trump claims the existence of an invasion at the southern border and invokes an unprecedented authority to, in his own view, terminate any possible way in which migrants crossing the border can access any legal protections that are available in the Immigration and Nationality Act that would allow them to stay in the United States. This will undoubtedly draw legal challenges. At no point in history has any president ever claimed this sort of authority before, and the Supreme Court has been clear that some of the authorities the president invoked here do not override the INA. Beyond shutting access to asylum at the border, the president has also ordered that DHS begin expanding extraterritorial application of the law to asylum seekers. And that means to send asylum seekers to other countries. He's going to do this a few different ways. First, through the Remain in Mexico program, which the Department of Homeland Security has been reinstated. Under that program, migrants were sent back to Mexico and required to return to the U.S. border for court hearings on a regular basis. Although DHS has said this program has begun, it is not clear whether that is actually true, and any individuals have actually been sent back to Mexico with a notice to return for a court hearing. We are monitoring this very carefully, but at this time, it is not clear whether the program has begun on anything more than paper. Second, the Trump administration has said that they are going to bring back the so-called safe third country agreements, or so-called asylum cooperative agreements that were signed in his first term. These agreements allow the United States to send migrants apprehended at the border or even potentially inside the United States to another country rather than allowing them to seek asylum in the United States. Despite what the Trump administration said last time around, there is no requirement under these agreements that an individual have ever been in that country before. For example, in the first Trump administration, they signed an agreement with Honduras that would have allowed them to send Mexicans to Honduras rather than let them seek asylum here. These agreements as well have not yet been signed, but so far indications appear that El Salvador may be the first country to sign a renewed agreement. More details of that will come, but as a note, the first time around, these agreements were found to be largely ways to simply avoid having the United States have to grant people access to the asylum process and simply force people to go to El Salvador or another country instead. It remains to be seen what nationals El Salvador will accept and what processes and procedures will be put in place. And then finally, at the border, we have seen the Trump administration move to deputize local law enforcement to help with border enforcement, as well as use the US military resources to begin the process of building more border walls. I'll get to the military stuff in a moment, but on the deputizing local law enforcement here, yesterday, Governor Abbott signed executive orders directing Texas DPS to work with the Trump administration to carry out border enforcement. This would be a significant expansion of Operation Lone Star and may give new authorities to Texas law enforcement officials to actually carry out immigration actions rather than in the past when they have only been enforcing Texas criminal law. Moving on to the changes about the use of the military. For context here, the US military has been involved at the border in the past. Specifically, there has been deployments at the border for many years. However, these deployments have really involved only the use of military for logistical support, filling out paperwork, watching surveillance cameras, transporting supplies from one place to another, even mucking out horse stables for the Border Patrol. What we are seeing now is a significantly more expanded role for the military at the border. Already, the US military has lent multiple cargo planes to be used to carry out deportation flights of migrants that were in Border Patrol custody when Trump took office. In addition, there has also been the military has also indicated that they will begin constructing temporary or potentially permanent physical barriers at the border, and the Trump administration wants 10,000 troops to be deployed to the border in total. I'll note that is at a time when right now border crossings are at their lowest level in many years. They were at a very low level. They're already at a low level when Trump took office, and they've plummeted in the weeks since then as many migrants take a wait and see approach. Beyond that as well, we are also seeing plans that the military will have a greater role in detaining migrants inside the United States. Already at the Space Force base in Colorado, the Trump administration is planning to use that to detain migrants potentially arrested inside Colorado or in Denver. Although these are not necessarily even migrants, these may be individuals who've been in the United States for many years. We are also waiting for more information as to what that's going to happen there, how many people might be housed there, how there will be access to legal counsel, and what conditions these people will be held in. It is also possible that there could be more military bases inside the United States used to detain people. They've already indicated that one possible purpose of this would be to essentially expand ICE detention resources far beyond what Congress has authorized by essentially having the military pay for this instead. And of course, yesterday news broke that Donald Trump signed an executive order saying that up to 30,000 migrants should be sent to Guantanamo Bay in Cuba at the military base there. This would be extraordinarily unprecedented. At no point in US history has any individual apprehended inside the United States for any reasons, terrorism or otherwise, been sent to Guantanamo. This raises very serious legal and constitutional questions as to whether they are authorized to do this and how they would carry out any kind of immigration proceedings for people detained at Guantanamo Bay. And there will almost certainly be legal challenges on this as well. But given that, I want to identify that the biggest theme here with the military deployment so far is that it has mainly been used for detention resources and at the border. At this moment, we have not seen any sign that the US military will itself be carrying out immigration enforcement. There were a lot of reports before Trump took office about the possibility of the military being deputized to do their own immigration enforcement. And as of today, we have seen no evidence yet that that has happened. We are keeping a very close eye on this and will continue to monitor the situation. But so far, the military still is largely being used for logistical support And the biggest change so far has been the use of military bases and military planes, but not yet the use of military officers to carry out enforcement. And with that, I will turn it over to Michelle on our legal team.
Thanks, Erin. Hi, everyone. I'm Michelle Lapointe. I'm the legal director here at the council. There have been a flurry of cases filed during the first week of the new administration, and many more are to come to challenge the anticipated implementation of some of these new policies. I'll highlight a few in the short time that we have today. First, as my colleague Adriel mentioned, there has already been a series of challenges to the birthright citizenship executive order. That executive order, of course, purported to say that the privilege of the United States citizenship does not automatically extend to people who are born in the United States if their mother was unlawfully present here or if she was on a temporary short-term lawful status, such as a visa or under the visa waiver program, unless the father was a U.S. citizen or a lawful permanent resident at the time the person was born. The executive order provides that starting with children born 30 days after the order was signed, so February 19th, no federal agency would be able to issue documents recognizing the U.S. citizenship of a child covered by the terms of the order. And it further directed the heads of various executive agencies to take all appropriate measures to ensure that the actions they carried out are consistent with the executive order. Now, this is a flatly unconstitutional EO and was immediately challenged in several different cases. The Constitution, the 14th Amendment, of course, guarantees that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This is well established. And of course, the multiple cases that were filed immediately after the EO was signed have a similar legal argument that this flatly violates the Constitution. The first case was filed by the ACLU in New Hampshire on behalf of organizations whose members will be impacted by the executive order. And again, the claim is basically that the plain text of the 14th Amendment confirmed by the U.S. Supreme Court in the 1898 case of U.S. versus Wong Kim Ark explicitly grants birthright citizenship for all people born in the United States. There are additional cases filed by several states, including the state of Washington and other advocacy groups in Massachusetts and Maryland, et cetera. And the first major court action that happened after the filing was that a district court judge in Washington state granted a 14-day temporary restraining order on January 23rd, which prevents the government from enforcing the relevant sections of the executive order. And there are motions for preliminary injunction pending in the other cases. Another case I wanted to highlight was the challenge to expanded expedited removal, which Nana spoke a bit about. And this was a case filed by the ACLU representing Make the Road New York, a membership-based organization. This was filed in the District Court for the District of Columbia. And it challenges the administration's expansion of expedited removal into the interior of the country, which essentially puts at risk anyone who cannot show to the satisfaction of an immigration agent that they have been in the United States for more than 2 years. There are huge due process concerns with how this could play out. Expedited removal is problematic even in its current implementation for all the due process issues it creates, but the idea that it could be expanded to affect people who have been in the interior of the United States for decades is extremely problematic. The claims in that case are under the Fifth Amendment to the Constitution and the Administrative Procedure Act, and that case is pending in DC. Very quickly, two other cases, three actually, I wanted to highlight. One is a challenge to the rescission of the protected areas memo. This was policy of DHS for many years that they would not carry out enforcement actions in sensitive locations such as schools, hospitals, and religious institutions. That was one of the first things to go under the new Trump administration. And they essentially said DHS, ICE can go into these previously protected locations and carry out enforcement actions. So Democracy Forward, representing a group of Quaker organizations, sued for the rescission of this protected areas memo. And they made really interesting claims under the Religious Freedom Restoration Act, the First Amendment, and the Administrative Procedure Act. Basically, the argument is that allowing ICE agents to investigate, surveil, interrogate, and arrest people at or near houses of worship substantially burdens their religious exercise and is illegal under the First Amendment and this federal statute. The end of CBP 1 is also being challenged as part of the existing case in Las Americas versus DHS, which is a previously existing case which had challenged the Biden administration's securing the border rule that had restricted access to asylum to only allow people to access the asylum process by getting an appointment through CBP 1 and going to a port of entry. The government had argued that was sufficient. They weren't violating the law because people still could access CBP 1. However, once the Trump administration eliminated CBP 1, the challengers pointed out that this argument didn't hold water anymore. So they have filed a temporary restraining order seeking to require the government to honor CBP 1 appointments and parole in a few individuals whose appointments were canceled after the inauguration, and that is pending. Finally, very briefly, there was a very interesting case filed in Chicago by Just Futures Law and the Northwestern University Law School, challenging the Trump administration's targeting of Chicago as a sanctuary jurisdiction. You may have heard about some of the raids that occurred over the weekend there. And they're filing on behalf of organizations who advocate for sanctuary and essentially saying that these raids are designed to chill the First Amendment rights of the advocacy organizations to engage in speech and petition the government, specifically because the Trump administration has said they wanted to target and pretty much punish Chicago because of its status as a sanctuary jurisdiction, and that its actions seek to end the group's advocacy to promote welcoming policies. There will be many more lawsuits to come. Many of them will depend on the agency's implementation of some of the directives in the executive order, and we will let you know down the road when we have more information on those. And I will pass it back to Adriel.
Hey everyone. So just quickly, I wanted to wrap up before we get into the Q&A and back to Dara, to talk briefly about sanctuary jurisdictions or sanctuary cities. As we saw under President Trump's first administration, there is an attempt to try to punish or force sanctuary cities to engage in supporting the federal government's federal immigration enforcement. For folks who don't know, sanctuary cities is not defined in law, but these generally include policies that are intended to create a greater level of trust and cooperation between local governments and local law enforcement and in communities with sizable immigrant populations. These policies can include, offering English classes, issuing municipal IDs or driver's licenses, and also limiting the use of local resources in federal immigration enforcement. And so what the executive orders do is explicitly mention that the Attorney General should look towards stripping sanctuary jurisdictions of all federal funds as a way to punish them for their policies. During the first Trump administration, most of the focus of this directive, which was done in 2017, was to try to put conditions on law enforcement related grants under the Department of Justice. There were lawsuits that prevented from those directives from being completely implemented, but it's unclear right now to what extent this second Trump administration will take this directive. Reuters did do an analysis in 2017 that found that the top 10 cities in the country could lose up to $2.27 billion looking at the federal funds that they were receiving. So it could be a huge impact on cities and states that have these types of policies. We have seen that the Department of Justice has taken steps already to try to intimidate some of the cities. On January 22nd, the Department of Justice issued a memo ordering federal prosecutors to investigate state or local officials who they believe are interfering with the Trump administration's crackdown on immigration. Most, if not all, sanctuary policies do already comply with the federal law, and it seems that this order was really more of a political stunt than an earnest order. In analyzing the actual limits of prosecuting local officials in this manner, it seems to be much more of an empty threat, because while impeding or interfering with federal law enforcement can be a crime, choosing not to help or to aid the federal government in this work is not. And just quickly, I wanted to mention that we are tracking a bill in Congress right now, introduced in the House, that's called the No Bailout for Sanctuary Cities Act, which has been named as a priority for the Republican Party. The bill would codify a definition for sanctuary jurisdictions and impose penalties for those cities that are considered that meet that definition by stripping essential federal funding from programs that serve both non-citizens and citizens. This could be, if it becomes law, this could be used by the Trump administration as a strong tool to bully cities into supporting his administration's mass deportation policies. And with that, I will pass it over back to Dara.
Thank you so much to all of our speakers. We have a lot of questions in the Q&A. Some of them we have gotten to by typing. Some of them we intend to get to live. What I would like to say generally at the outset of this, that we cannot speak to anything that hints at specific case circumstances, because we, for legal ethics reasons, can't do anything that can be construed as legal advice. And we're not going to speculate on actions that the administration might take in the future that aren't indicated by anything they've done yet. But saying that, I'd like to start by asking a question that a lot of folks have had to Adriel, which is, can you talk a little bit more about what this means specifically for Afghans and Ukrainians who've come to the U.S. in response to war in their respective countries?
Right. So I think right now what we do know is that there was a directive given to the Department of Homeland Security, which ordered a review of all parole programs to determine which are considered categorical parole programs, and issued a pause of processing those programs while the review is being conducted. This does include Afghan programs that do include the Afghan community, also Ukrainians. It also includes, there were some questions about the Central American Minors Program. There was also another program around family reunification that was established under the Biden administration for certain countries and then expanded from previous countries like Cuba and Haiti. So our understanding right now is that those parole programs are paused, but those are while this review is being conducted, but this is forward-looking. It's not impacting people who currently have parole. There was a memo issued by the Department of Homeland Security around immigration enforcement actions and empowering immigration agents to be able to review and potentially revoke parole in individual situations when they're reviewing a particular person's case. We don't know exactly right now to what extent that's actually going to be enforced. And so we're still waiting to hear about that, but there is a memo that particularly focuses on immigration enforcement actions in that authority. But there is nothing in these executive orders, and we haven't heard more broadly about any larger plans around impacting folks with parole right now. But if a person does have a pending application, the understanding is because of this directive that they're currently paused.
Thank you so much. I'm going to send the next question also to you, Adriel. I think that there are just a lot of questions about various parole programs, and so I'd like to, and other discretionary programs, and so I'd like you to talk a little bit about the future of the Central American Minors Program.
Well, it's hard for me to be able to look into the future, and it'll tell the future, right? But right now we don't know. It's paused. We do know that it was targeted by the Trump administration previously, and so given that it particularly defines a particular population to come into the United States. It's particularly for children of parents who are already in the United States. The parents have could be in some type of lawful status or temporary status, and so I can't say with complete certainty what will happen to it, but it does seem like it's at risk of being suspended indefinitely by the Trump administration.
Thank you so much. I'd like to put the next question to Naina. Can you talk some about the Laken-Riley Act and how that interacts with everything we've seen?
Yeah, thanks, Dara. So the Laken-Riley Act was signed by President Trump yesterday, passed by Congress in the first few weeks of the new congressional session. And I should just, say up top, a lot of what we're talking about today is obviously executive actions from the president. What's true is that bills that are passed by Congress in this new session on immigration will work in tandem with Trump's actions to make their agenda easier to enforce. In other words, what's happening in Congress matters just as much as what we're seeing by way of executive action. The Laken-Riley Act essentially expands mandatory detention under the Immigration Nationality Act. Mandatory detention says that somebody who is detained under that provision does not have the right to a bond hearing. They don't get the opportunity to go to an immigration judge and make the case for bond to say, look, I'm not a danger to my community. I'm going to show up for my court hearing. I should get to be in my community while I fight my immigration case. Instead, people subject to mandatory detention remain detained through the course of their immigration case. The Laken-Riley Act says that anybody here who's undocumented, because they entered without inspection or they overstayed a visa or they don't have certain documents, would be subject to mandatory detention for a mere arrest, charge, or offense related to things like shoplifting, larceny, burglary, theft. In other words, what the Laken-Riley Act is doing is trying to sweep in more undocumented people for mandatory detention, in some instances based just on a mere arrest. The Laken-Riley Act could also apply to people with certain kinds of lawful status, who may not have the documents and paper that the Laken-Riley Act requires. It's worth knowing that. And then the other part of the Laken-Riley Act to note is that it gives state attorneys generals the standing to go to federal court and ask a federal judge to issue an order against the US government in 5 areas of immigration policy. And those are sweeping areas of policy that would essentially allow states to dictate individual decisions ICE officers make about releasing people, or much larger decisions, like the decision to continue issuing visas to an entire country. So the Laken-Riley Act, again, is an example of a harmful anti-immigrant bill that will allow the Trump administration to sweep in more people in its enforcement actions in the interior and subject them to more harmful forms of detention.
Thank you. Erin, I'd like to ask you the next question. Can you talk some more about the impact of these actions on the private sector? Have we heard anything from industries that might be particularly affected by enforcement, such as the meatpacking industry?
Yeah, I think we have already seen a lot of concern from employers, especially those who work in industries that do have a fair amount of undocumented labor, but also in industries that don't, that hire people, for example, who have parole or temporary protected status, people who are legally working here with a work permit. If the Trump administration, well, I would say for the undocumented immigrants, we have heard anecdotal reports so far of people not showing up to work, not showing up to school. And so there could be potential impacts to our food sources, to support, to people who work in restaurants, and to sort of many of the millions of people who do essential jobs in the United States who may now not come to work, or who may be arrested and not be able to work for that result. But we are also looking at the possibility that by terminating temporary protected status and parole protections, that the Trump administration could kick hundreds of thousands of people out off of the ability to legally work. For example, should the Trump administration actively terminate temporary protected status for Venezuela over the course of the next year, in April and in September, there will be upwards of 600,000 people who lose their ability to legally work in this country. And that could have very significant impacts on the US economy, on employers, and in communities where those people have been living for now, in some cases, upwards of 4 years.
Thank you so much. Michelle, can you talk to us a little bit more about this registration provision that the administration cited?
Yeah, so there was a part of one of the executive orders that discussed a fairly obscure part of the Immigration and Nationality Act about a requirement for certain non-citizens to register and how the failure to do so in certain circumstances could be a misdemeanor offense. And, this is one of those we're waiting to see if there's additional guidance on. We did see a memo from the Department of Justice instructing its prosecutors to prioritize certain immigration-related crimes for prosecution, including this registration provision, so it could become a bigger deal down the line. But as of right now, it is unclear who would be targeted for violations for prosecution and arrest based on this provision, because there is not currently a mechanism for most people who are undocumented to register. So we'll have to wait and see what they might implement to create a registration system. But right now, there just doesn't exist that kind of mechanism. And it is unclear which sorts of documentation would be considered sufficient for registration purposes. But as an overall point, I think we just need to understand this as the administration's effort to greater criminalize folks, to make them amenable to arrest and prosecution, to expand the numbers of people who could be caught in these sorts of dragnets by using a misdemeanor provision of the INA that really has not been used before. Except with one major exception is what's called the NSEERS program, which was after 9/11 and targeted certain nationalities to require them to register and to prosecute them for failure to do so. That program has not been in effect for a long time.
Thank you. Adriel, one question that we've seen is, can a sanctuary city be obliged to follow the latest Trump administration's executive orders and to cooperate with raids? Can you speak to that a little for us?
Yeah, I can. And so I think we have to start off with the Constitution. We do have a federal system where the states and localities cannot be forced by the federal government to impose or to enact or further federal particular federal policies. I mean, there are some nuances there, but generally there is a distinction when the federal government wants to force local law enforcement, for example, to actually engage in immigration enforcement. And so generally, the federal government can't do that under the 10th Amendment. They can't coerce or commandeer state or local resources in that regard. There are programs where local governments can willingly and voluntarily enter into agreements with the federal government to enforce federal immigration law, which we've seen through 287G agreements like Nana talked about. And so there can be cooperation, but it has to be voluntary. Of course, the issue here is that sometimes the federal government does put conditions on federal programs, federal like funding programs, to impose certain priorities. And so that's what they tried to do in the last administration, the last Trump administration. The issue there was that the Attorney General didn't have the authority to be able to put some of those conditions on some of these law enforcement related grants, and met a lot of barriers through the lawsuits in being able to do that. I do think that it's really important to highlight something that I did talk about previously, about this bill that's moving through Congress called the No Bailout for Sanctuary Cities Act, HR 32. That bill could provide a tool, could empower the Trump administration to be able to deny particular funds to cities that fit into the definition of sanctuary jurisdictions, which include cities that don't honor ICE detainers or those requests for transfer, for detention and transfer from local custody to federal immigration custody, or who don't notify ICE if somebody is being released from a local jail. And so if this bill passes, then it could give the federal government a tool to be able to force sanctuary jurisdictions to comply with requests from the federal government. So it is really important for people to think about maybe advocating and talking to your congressmen, your representatives, and your senators, and really pushing back about this bill. And we are going to be having a take action on this as well. So please do sign up for our emails and you'll get more information about that.
Nina, I have a follow-up on that I'd like to direct to you. Similarly, we've talked some about like what cities are obligated to do. What are individual people who might come into contact with ICE obligated to do, and what are their rights in case that happens to them?
Sure. Thanks, Dara. The thing to really remind people on the ground and educating them about their rights is they do not have to let ICE into their homes. Schools do not have to let ICE into their schools. The ICE warrants for arrest are administrative warrants. They are not formal judicial warrants. People are obligated to comply with a judicial warrant issued by a neutral decision maker or judge, but a warrant issued by ICE, which is a sub-agency in the executive branch, is an administrative one. And so people have the right not to share their citizenship information when asked. They have the right not to let ICE into their homes. This education is critical. We saw arrests in Chicago this past week. We heard one of Trump's advisors, Homan, on TV saying that they were unable to effectuate as many arrests because people were aware and educated on their rights. Organizing and informing communities of their legal rights is a key way to protect them in a moment like this. We're happy to share separately Know Your Rights content that's available specific to schools and the rights that exist there, as well as at hospitals for healthcare providers. There are many organizations that are putting out those materials, and we'd encourage folks to make sure you're disseminating that in your communities as well.
Thank you. Michelle, we've had a lot of questions about DACA recipients. Can you speak to whether there's been anything that targets that particular group of people?
Yeah, sure. We have not seen in the first week of the Trump administration anything in particular that targets DACA recipients. Now, there is sort of a trend, as all of my colleagues have mentioned, of stripping away or attempting to strip away legal protections that people have to make them amenable to deportation. Nothing like that has happened yet with DACA in this administration. Of course, the first Trump administration tried to get rid of DACA and were ultimately unsuccessful in a case that made its way all the way up to the Supreme Court. But it is important for people to know that separately, there is an ongoing court battle. In fact, a decision came out from the Fifth Circuit Court of Appeals just 3 days before the inauguration that essentially affirmed the holding of a district court judge in Texas that said that DACA violates the law. However, It is really important to understand this. It did not change the status of current DACA recipients. If you have DACA now, you still have it. Nothing about that court case has impacted your status currently. And we're going to actually have a blog coming out, I think, today about that decision that kind of breaks down the course of the proceedings and where we are now and what could happen next. There's still some legal wrangling to occur, and that could be one of the reasons that the Trump administration has held back for now on issuing anything specific to DACA, because it is still active in the courts. But the important point to know is if you have it now, you still have it. You have that same protection. If you have an EAD through DACA, you still have that protection. That might change in the future, but not now.
Thank you. Aaron, one probably last question for you. Do we have any insight into how the executive order to ensure immigrants are vetted and screened to the maximum degree possible might affect future visa applicants?
Yes, we don't, well, I would say we don't have anything specific as of yet. And crucially, even when there was a new executive order on supposedly fighting anti-Semitism that was issued yesterday that further calls on changes to the visa programs. The key thing to understand about that executive order, as well as the ones that have been issued so far, is that we have not yet seen any guidance or implementation on them. The administration is going to likely issue some changes to the visa programs. The orders direct changes to the Foreign Affairs Manual and other processes under which people are screened overseas, but we haven't seen that implemented as of yet. However, we can look back to what happened in the first term and understand that we are likely going to see significant increases in the red tape, bureaucracy, and costs involved in legal immigration. The Trump administration in the first term did succeed in cutting, in particular, family-based immigration, and we can expect once again to see not only an increase in red tape, but a new type of ideological screening for individuals seeking visas to the country.
Thank you. With that in the, I know that there are a lot of questions that we haven't gotten to. In general, I would say that if you have questions about specific cases or case circumstances, that it's generally wise to contact an immigration lawyer and ask about those. A lawyer will be able to speak to the specifics of a case much better than somebody who is just generally speaking on a webinar. I'd like to thank all of you for participating, for watching this webinar. We will be sending out a recording afterwards, and in addition to written materials, which will include both our fact sheet on the executive orders that were signed on the first day, including links to the text of those orders themselves, other materials, including Know Your Rights resources. I'd like to thank all of our speakers for participating in this webinar, and again, to thank all of you. And you should look in your inbox for materials and further steps that you can take. Thank you so much. Have a good day.